the will and testament, why the help on the role of being the general executor is so important. It gives us an ability for some remedy whilst the UCADIA community and the financial system is turned on. Thank you. I would like to have it there because I need it, but at a grassroots level. But I have not been able to get past the fact that without the rules, without those being absolutely rock solid, any example of misuse can be used as an argument to show that the system is flawed. So that's the long answer, Lee, sorry, as opposed to the short answer. I just want to get to East Pennsylvania, who's waiting on the line, so let me get on to East Pennsylvania. East Pennsylvania, can you hear us?
Segal.
Hey, how are you?
Good. I've been having difficulty. I'm getting Magic Jack on my home phone, and I finally got a good line, finally, to you, so I can talk and hear you. Because I've been having some difficulty. They're playing with me again. I have contacted the people from the UFO, which are having the same problems as we are, and they're also, in agreement. I spoke to Linda Moulton Howe and not George Burns. That's Bill Burns from the UFO community, and they're going to try to cooperate with us and pass information to us that they're doing. Not against the government, to build a new government and to get information out and get things correct, because they're having the same difficulties as we are. And also, I've spoken to several people within their group, and they're very interested. And I'm going to pass the number on, and hopefully they'll get online eventually.
Very good.
So we can keep on growing. But as I explained to them, hey, it's like this. If you're interested, if not, let's at least start a cooperation here. And everybody's an automatic member, so it's all good. And you don't have to register or anything like that. You'll still be safe, because a lot of people are worried about, this and that. So, but that's what I have for this week. And go ahead.
Well, I was just going to say, I'm really glad to hear your voice, and you've gone through some major health issues, so I'm great to hear your voice and great to hear that you're up and about. So, yeah,
I'm back to work already.
Very good.
Yeah, I'm back to work this week.
Well, look, you go. Okay, keep going. Yep.
Sometime, not tonight, because I have to go to work tomorrow. But if you'll call me tomorrow night, I'd really appreciate it, because I got some things I want to talk to you about.
Yeah.
I actually, there's difficulties getting through that I'm having, somehow it's on my house phone. They can't hear me, so they're starting to play with my house phone again. So I'm gonna have to fix things that way. But there's a couple things which are happening in this area which I'd like to talk to you about. Okay.
Mm-hmm.
And basically, it's on what's happening with the movements here. I know. Ron and Greg have talked to you about it, but I want to tell you what I've seen, because I'm not that far from Washington. I'm really not that far at all.
Yeah.
I'm within. Washington's probably 90 minutes away.
Yeah.
But a lot of the bases are right here. Right within a half hour. So, and give me a call at home. Okay.
All right, I'll give you a call tomorrow, but stay well, stay safe, and we'll talk. All right, good on you.
Yeah, Honor, you be good.
Honor. Okay, bye.
Bye.
That was great. It was Ray Johnson, who's been doing some fantastic work with the indigenous nations and tribes right up and down from Central America north, and it's great that he's back up on his feet, and so we'll talk to him. Let's see if we can just have a quick where we see Lynn. So let me unmute Lynn, and then we'll go to more questions in the chat. Hello, Lynn. Can you hear us?
Hi, Frank. Yes, I can hear you. This is just real brief. On the will and testament, wasn't the old term testamentum And wasn't will something that was kind of added maybe as some trickery? And I'm wondering if we use an affirmation that is discussing the testamentum. They use testimony all the time in their system, so it's just a thought.
No, it's a good point. The Wills Act. So, in terms of the creation of the model of probate, intestate, wills, trusts, and administration that the corporation and the corporate courts use to conduct 95% of all court cases, all of that is a product of this Wills Act and this concept of the model of will and testament. So you're absolutely right. Testamentum and the word affirmation have a similar provenance. The challenge we have in UCADIA, we state that one does a testamentum, one doesn't do a will. We identify the provenance and the history of it. But the challenge in their system is to overcome this presumption that we're intestate, we are without a will. So it's a whole legal fiction they've created, and I hear what you're saying. And the problem we're having is not only have they created this legal fiction, but they've sealed off every door, it appears, at a corporate level to do something about it. So I think the idea of using affirmation to accomplish similar things may be an avenue. I think the publishing of notice in gazettes will be another avenue. But as Ron said, at no point have we said we need to record the physical will, because under their own rules, you don't need to physically record the will, only the existence of the will, and that is the issue on the public record that's determining whether we're intestate. Yeah?
Yes, I agree.
Yeah.
So, okay, well, that was just a point I wanted to bring up.
No, it's a good point, and the connection between the two is a really, really good point to raise. And then I just want to say to you, for everyone to put it on the record too, thank you so much. I know that people really, really value the synopsis that you do, and you do it all for nothing. So, I mean, thank you.
Well, thank you, and I do it all for the learning, so I'm pretty selfish about it. Others can learn a lot by getting in and listening and typing and everything. So I'm absolutely glad to do it. Take care.
Thanks, Lynn. Thank you.
Okay. Bye-bye.
Bye. Well, in the few minutes before we finish, we might wrap up tonight. We get a few more questions here in the chat, and if any callers want to speak in the last few minutes, please press *8 or #8, and we'll get to your call before we wrap up. But I think there was a couple more quick questions here I saw earlier that I might have missed. The question Guest 14 asked was, is the county recorder the same as the clerk of court? In some cases, yes. In some cases, I'm honestly not too sure. But the clerk of the court tends to also be the county recorder, but also potentially the town clerk as well. So it tends to be a role that's wearing more than one hat. So the answer to that question then is yes, but not as an absolute. I'm going to get into the next caller, Gypsy Rose, and then Ron's back on, and then we'll wrap up tonight. Hello, Gypsy Rose. Can you hear us? Hello, Gypsy Rose. You're unmuted. Can you hear us?
Oh, Frank, I'm sorry. I was muted here. This is Greg. I'm using Gypsy Rose's phone.
Oh. Hey, how you going?
I'm good. How are you today? I know you're good because you've already answered it 4 times. So, hey, I want to make a comment, an observation about a little bit of the presentation that was made yesterday regarding this 14th Amendment issue, and maybe as far as UCADIA goes, put this to rest once and for all. if it's at all possible. I'd like your comment on it then and see if I've got this right. But it's my view that the 14th Amendment was a stepping stone along the way to create the District of Columbia Act and then the implementing legislation afterwards. And to sum it up, I would say this, that Abraham Lincoln's War Between the States, War of Northern Aggression, or also known as the Civil War, was a beginning implementation of a transition into a corporate government. Something that had been working for quite some time, even during the Andrew Jackson administration, with the battles with the central banks, and then the final capitulation with the war. But I was also wondering, just to tie this together a little more, but if the 13th Amendment, which was, I believe, in the first decade of the 19th century, which said that nobody with the title of nobility could hold any public office, I'm still not clear to this day whether Abraham Lincoln actually was an esquire when he was elected president, which might also make his presidency completely illegitimate from that standpoint. But it suffices to say that once he completed his issuing of permanent or of the martial law executive orders and those continuations through today, then you take the initial civil rights acts and the legislation that were put through, which evidently weren't strong enough to bring the South back under control of the North as far as their legislatures go. And, of course, then the 14th Amendment was the next step to try to bind the South and under the control of the North. But I believe that wasn't even sufficient then with the need of the 1871 District of Columbia Act, excuse me, and then the implementation of those, which was then the completion of the full implementation of the corporate takeover. And, of course, we've talked about that with California having two constitutions, its pre-Civil War Constitution and its post, I think it's 1879 was the second one where it became a corporate state. And, of course, in Idaho, then we've known now that Idaho was always established as a corporate state. So if it was my conclusion is that what many of the researchers who have read several books on the 14th Amendment have concluded is pretty much irrelevant. And even though it's a part of the stepping stone, solving the 14th Amendment problem isn't going to solve the ultimate issue of having this corporate system recognize anybody as having standing.
Well, again, standing, as we've discussed, as you know, is a term that actually directly relates to the function of probate court. And standing ultimately means either you have brought a claim to the court against the estate, in which case, by virtue of you bringing a claim, you have standing because you are the one bringing the matter, or you are appointed to the estate in the capacity of an executor or an administrator or a fiduciary. And if you don't hold any of those particular relationships, and we don't, if we are standing there as a defendant, then you have no standing. I agree with you absolutely that the 14th Amendment is a stepping stone, and that when you just look at how they implemented the concept of enemy of the state at the beginning of the 20th century,
yes,
and that's before we even got to the concept of alien brought in, that they went way beyond the 14th Amendment by effectively declaring everyone an enemy before they declared everyone a criminal. So, we talk about the system, and I said this a few talk shows ago, but I'm going to say it again because it is relevant, because there may be new people monitoring our calls, there may be new people on the calls. I believe that every society and every member of society must, as a matter of duty, contribute to the benefit of that society. But I have a fundamental objection to a system of contribution, which was currently called taxation, which is based on the premise that in order to make it quote-unquote legal, it declares each and every one of us a criminal. I object to that system that perverts the law and perverts me in order to make a contribution effective. And then, of course, allows a whole swag of people who can easily afford to contribute to do nothing.